We go all the way to the SCA in terms of a matter where the position was settled in terms of AB and another versus Minister of Social Development under or heard in the Constitutional Court. And what happened here was it was a matter where two parties essentially approached the court and they wanted to have a surrogacy agreement registered so that they could go through the surrogacy process. What happened here was the court had to deal with whether there had to be a biological link between one of the commissioning parents and the gamete which is used in terms of the surrogacy arrangement. Now, Section 294 of the Children's Act says that it must be the gametes from both parents, or if that's not possible, one of the parents that must be used in terms of the pregnancy, so that there must be a genetic link between one of the parents and the child. The parties approached the court to say that this is unconstitutional because there is now a position where they want to do a surrogacy using essentially the same DNA material as one of the children, so that the child to be born would have a genetic link with its sibling and not with one of the commissioning parents. The SCA basically dismissed the appeal and said, look, it is constitutional because there is an imperative. As mentioned, the text and context reveal the purpose. It is to protect the child to be born by creating and establishing a genetic origin of a child to at least one of the parents, which is important for self-identity. The SCA, under the pen of Mokotloa J.A. with Motle Mabindla Bukwana and Kwele J.J.A. concurring, and this is, I'm so sorry I didn't give you the citation, KB and another versus Minister of Social Development. You can all hear the fatigue coming into my voice and my brain at this point in the proceedings. ZASCA 54, 19 April 2024. The provisions of Section 294 of the Children's Act being found to be constitutionally sound.